So, welcome back all participants and panelists for this session. And it's a great honor and privilege for me that I've been asked to chair this session. The amidst of like a very eminent person. Please closer. So, very eminent speakers. We have 4 speakers in this particular session. The broad theme for this particular session is Indian courts and human rights. So we are going to discuss about that. We have Sri P.K. Malhotra ji, former Secretary Ministry of Law and Justice, and Dr. G.V. Rao, Senior Advocate and Vice President of Indian Society of International Law. We have Mr. Saju Jacob Sir, Advocate Supreme Court, and Binay Singh, Dr. Binay Kumar Singh, Indian Society of International Law, Assistant Professor, Indian Society of International Law. What we have decided that we'll have 15 minutes for each speakers in this session, and maybe 10 to 15 minutes if we have time, we'll go for some question answer session. So with this note, without much delay, I request Sri P.K. Malhotra sir to share his thought about the topic he has chosen, Supreme Court and right to health. That is the right to health and environment, or do you want to speak something?
No, it's fine. Environment, healthy environment.
All right.
Supreme Court and right to health.
Okay, thanks. Sir, I will simply appreciate if you adhere to the time, 15 minutes.
Sure.
That will be good.
Professor Manoj Sinha, Director, Indian Law Institute. Dr. G.V. Rao, Senior Advocate and Vice President, Indian Society of International Law. Dr. Saju Jacob, Advocate. Dr. Binay Kumar Singh ji, dignitaries of the dais, distinguished invitees, delegates, and dear students. Best wishes to all of you on this celebration of Human Rights Day. Celebration of Human Rights Day, as I personally feel, is not a ritual. It is to refresh our commitment and reminder for the duty we owe to the society for our respect to the human dignity. I thank the Indian Society of International Law for making me a part of this panel with the distinguished speakers. I was asked if I can share my thoughts with you on the right to healthy environment for all living beings, as it is our collective and individual responsibility to preserve the environment in which we live. So I would be referring to some legal framework as we have in our country, and then how the judiciary has, more particularly the Supreme Court, has contributed in protecting our right to healthy environment. This is the time when we are organizing this conference, when you find the pollution, more particularly in this area, we are holding this conference. I think it is in the worst situation, and not be at this time of the year you face the worst environment. But for the initiative taken by the Supreme Court or the orders passed by time to time by the Supreme Court for clean environment, not from today but right from early 80s, I think we have not been able to even breathe what we are doing it today. So right to healthy environment is core to the right of life. It is in many ways connected to the right to clean drinking water and right to health. It also prevents humans from damaging flora and fauna. This right has been recognized and advocated by the United Nations and was accepted as a global human right at Stockholm Conference, also known as Magna Carta of Human Environment. It provides a much required basis for environmental protection to environment activists. Talking about our constitution, there is no, I will say, specific fundamental right under the constitution for the preservation of environment. However, Article 21 of the constitution, which is right to life, it talks about it provides, rather it has been read, right to life has been read as a right to a clean and healthy environment as a fundamental right, because the article simply says, if you read Article 21, it simply says no person shall be deprived of his life or personal liberty except according to procedure established by law. But the Supreme Court has interpreted it by saying that when we are talking of right to life, it's not a right to life to live in a vegetative state, but right to healthy environment, right to education, which is now recognized as a separate independent right, and right to legal aid, right to have expeditious justice delivery system. So many rights have been read, right to shelter, right to food, have all been read into Article 21. And the right to environment has also been, free and fair environment has also been read in Article 21 of the Constitution in various decisions given by the Supreme Court. In addition to that, the amendments which were made by the 42nd Amendment in the Constitution, Article 48A was added, which specifically provides that the state shall endeavor to protect and improve the environment and to safeguard the forest and wildlife in the country. Again, as I say, this is a directive principle of state policy, and to implement this directive principle of state policy, many laws have been enacted by the Parliament. I'll just make a passing reference to them because of the time constraint, and I'll come to it a little later. Before that, I would also like to draw your attention to chapter 4A added in the Constitution by 42nd Amendment, which talks about the fundamental duties of the citizens. And one of the duty, as enshrined in Article 51A clause G, is it is a duty of every citizen to preserve and protect the environment, and it reads, it shall be the duty of every citizen of India to protect and improve the natural environment, including forests, lakes, rivers, wildlife, and to have compassion for living creatures. Now, I think these two additions made in the Constitution by 42nd Amendment are very, very relevant for all of us. And as I said, that I will be talking about certain laws which have been enacted by the Parliament. Because of the time constraint, I will not go into the detail as to what they contain, but relevant laws which I am referring to are Wildlife Protection Act of 1972, Water Prevention and Control of Pollution Act 1974, Air Prevention and Control of Pollution Act 1981. These are the legislation which were earlier passed, and later legislation which I want to refer into a little bit of detail, and which the Supreme Court has passed various order from time to time, exercising its power in exercise of the power given under the public interest litigation and exercising its power under Article 142 of the Constitution, or issuing a writ jurisdiction under Article 32 or 226 in the High Courts. The other legislation are the Environment Protection Act of 1986, which according to me is a very, very important legislation, because the primary motive of the Environment Protection Act is to provide for the protection and improvement of environment. The Act empowers the Centre to take appropriate measures to prevent and control the environment by managing hazardous waste, regulating the location of industries, and protecting public health and welfare. This Act is an umbrella legislation that is designed to provide a framework so as to initiate the coordination of state and central authorities in protecting the environment. And for its implementation, the all other legislation which I mentioned earlier, and more particularly this legislation, the National Green Tribunal Act was passed in 2010, whereby the National Green Tribunal has been constituted. And this tribunal is required to quickly resolve cases relating to environmental preservation and protection, as well as the conservation of natural resources. This Act is enacted under Article 21 of the Constitution of India, which explains the right to live in a clean environment and the right to a healthy environment. One of the objectives of NGET is to give compensation and relief for any damage caused to an individual or group which power was not available earlier. But giving such a power to the tribunal, anxiety was that the citizen can breathe a clean air and we leave a better environment for our coming generations. Now, having referred to the legal framework which has been created by the government or by the Parliament, now I come to the judiciary. And I find, I'm happy to say that the judiciary has played a very, very vital and very important role in protecting the environment, as well as to see that the provision of these legislations which have been enacted by the parliament are not given only literal interpretation, but they are given an interpretation which subserve or serve the object for which these acts have been enacted. In the protection of environment, the judiciary plays a very important role. Various judgments in the recent past are the proof of judiciary playing a significant role in interpreting the fundamental rights of an individual. Along with this, the introduction of public interest litigation helped those who are not able to approach the Supreme Court for protecting their rights. The concept of PIL, as all of you know, encouraged various individuals, non-government organizations and other related organizations to approach the court for helping those who cannot afford the court fee. I would like to refer to some of the decisions which have been given by the Supreme Court, and more particularly in public interest litigation. Of course, there are large number of judgments now, at least from 80 onward to this time, they run into hundreds. But 3 or 4 which have come into the initial stage where the people were really sensitized, starting from the time of Justice Kuldeep Singh, when he interpreted the provision of the Environment Protection Act way back in 1980, this Act of 1986. I would refer to few cases where actually the Supreme Court was concerned and was saying that the provision of law as enacted by the parliament are not being implemented and people in authority are violating it. And one such case is, of course, MC Mehta versus Kamal Nath, in which the Supreme Court took notice of a news report that was published in the Indian Express under the caption was, Kamal Nath dares the mighty Vyas to keep his dreams afloat. And what was this case? The problem was with Span Club. Span Club, an aspiring project on the banks of Vyas. The club represents Kamal Nath's dream of having a house on the bank of Vyas, in a shadow of bank of Vyas, in the shadow of snow-capped Janskar ranges. The club was resurrected after encroaching 27 bighas of land, including substantial forest land which was later leased out to the company when Mr. Kamal Nath was Minister of Environment and Forest. The main contention was that course of the river was being diverted to save motel which was being constructed there from future flood. The inspecting team in its report stated Span Motels did not engage any flood control expert and work was not properly done, which could result in future floods and landslide. Therefore, the Supreme Court ruled that public sees no reason to prevent the public trust doctrine from expanding in order to include all ecosystems operating in our natural resources. Resources meant for public use cannot and should not be converted into private ownership. The polluter pays first principle has been held to be a sound principle by the Supreme Court in the Indian Council for Environmental Legal Action versus Union of India. One who pollutes the environment must pay to reverse the damage caused by his acts. The public trust doctrine, as discussed by us in this judgment, is part of the law of the land. This is what the Supreme Court has said. Another important decision and another important landmark judgment which I would like to refer is the Taj Mahal case, where Taj Mahal, which is one of the 7 wonders of the world recognized by the international bodies, the UNESCO also, is the finest specimen of the Mughal architect to exist in India. However, it stood in a pitiable state, with the marble having turned yellow and deteriorating because of the chemical pollutant from the nearby industries. In public interest, a petition was filed before the Supreme Court, and the Supreme Court judgment said the Supreme Court recognized the need for the protection of Taj Mahal and found the industries guilty of the condition that the monument was in. The court relied on the precautionary principle and held that environmental measures must anticipate, prevent, and attack the causes of environment degradation. It also placed the onus of proof on an industry to show that it operates in a manner that is environmentally benign. This case thus broadened the definition of the right to live and was able to limit industrial practices that were harmful so as to protect the people's right to live in a safe environment. I can go on and quote many other decisions, but the one important decision which I would like, more particularly because we are sitting in Delhi and now we are facing this pollution in the environment also, with regard to the vehicular pollution which is caused in Delhi, and this was a case which was filed as a public interest litigation seeking a direction from the Supreme Court as to how the vehicular pollution in Delhi can be controlled, and the Supreme Court appointed a 4-member committee comprising of a retired Supreme Court judge, and this committee recommended measures to control vehicular pollution nationwide. Orders were passed for the supply of lead-free petrol and use of natural gas and other fuel as substitute for conventional fuel, and also carried out. Lead-free fuel had been introduced within 4 metropolitan cities from April 1995, and all new cars that were registered from April 95 onward are fitted with chemical action converter. I think this was a game changer judgment for the simple reason that not only the diesel vehicle which were causing pollution were stopped, diesel public vehicle which causing pollution were stopped, but at the same time it gave an opportunity or opened an avenue for exploring other possibilities, and now you find even the electronic vehicle are coming, even better vehicles are coming where the fuel consumption is little lesser, and I think even the quality of the petrol is also improving, because once you go to the petrol pump, normally he will say whether you need an element to be added to your petrol which will reduce the pollution. So I think all these developments which have taken place for the implementation of the laws passed by the parliament, the judiciary definitely has a very important role to play. And I have referred to only few cases of the apex court which have helped us to breathe clean air and get unpolluted environment. NGOs and public spirited organizations and individuals regularly use the route of public interest litigation to ensure a better environment for all living beings. Role of judiciary in this regard need to be appreciated. But I would have taken a little more time, but because of the time constraint, I would like to conclude and say that it is the duty of all of us. Don't leave it to the judiciary. Don't leave it to the government. It is duty of all of us to ensure that we too contribute our bit to leave a better environment for our coming generation. If at least we cannot add anything, at least we should not try to spoil the environment anymore, which has already been spoiled. With this, I convey my thanks to the chair for affording me this opportunity to express views on this important day when we are celebrating the National Human Rights Day, to speak on environment related issues. Of course, we have other speakers who will be talking on other topics. Thanks to ISIL for affording me this opportunity to share my thoughts, and thanks to you.
Thank you very much, sir, and you have nicely covered the entire legal framework in a very short span of time, in 15 minutes, about the protection of environment under the Indian Constitution, and particularly you emphasized on the part 3 of the Constitution, part 4 of the Constitution, and part 4A of the Constitution, which, like, generally they say is troika, with part 3, part 4 and part 4A of the Constitution. This is also very important to highlight that India, in the current Conference of Parties meeting which is going on and which will be ended in 2-3 days time in 12th of December, India has ranked 7th in the world, particularly that is the Climate Green Performance Index. Climate Green Performance Index, where we have done much better than the European country. Worst country is the United States, then China when it comes to the environment policy. There are issues and challenges also there in when we talk about the environment, particularly how to balance between the development and environment. That is the major cause of concern. Of course, people are talking about the global level and also in the domestic level, environmental sustainability and business, the issues and challenges. Those things are very important. We have to. You have highlighted also the polluter-pay principles, precautionary principles, and very nicely you talked about in detail about the public trust doctrine in the case of Kamal Nath versus Union of India. And actually today is also the human rights, like tomorrow is on the eve of the Human Rights Day. So when I look into the human rights in the, even the Constitution 48A and 51G, later on it has stated, clearly stated, otherwise court has been looking into in more, in fact it developed after environment jurisprudence. If we go, we see more after the amendment for the second constitutional amendment onwards. Prior to this, I'm not quite sure how court has looked into, but after that is there in that particular time. But when we look into the international framework, there is only one instrument which talks about long time back, and that is very important. Protection of environment is the African Charter on Human and People's Rights. That is the one instrument which clearly states protection of environment, and that is no other human rights instrument which has a provision talking about the human rights and protection of environment except the, and that instrument was drafted in the 1981 and came into in force in 1986. So like, they were much advanced, even they were under the colonial powers, and they became independent, most of the countries, and gradually they thought about the environment, and it has been inserted in the human rights environment. You also highlighted about the role of NGT 2010. I just end with saying one thing, which I think when we talk about the environment, we must also take note of the Bhopal tragedy case, case. That is very important, but generally we start from 1986 onwards, but whether what happened on that particular time is still impact society is feeling in the Bhopal and others, particularly month of December, on the 3rd December 1982 and 3rd December 1983. So some way we have to analyze such kind of disaster, whether we are prepared, whether we can manage. There are a lot of crises are happening on that. So big challenges, as you say, that young students, you all have a duty. You all have a duty to play very important role, and particularly like our Prime Minister keeps on saying on the Amrit Kal. So this Amrit Kal will become Gaurav Kal. So Gaurav Kal, you have a responsibility. You are going to be there to take care of the protection of environment and also the human rights. So thank you very much, sir. Moving on, I have a next speaker, Dr. G.B. Ross, sir. He is a senior advocate in Supreme Court and also the Vice President of Indian Society of International Law. Sir is going to speak on the abuse of reservation of treaty system by states, remedies and international. Over to you.
Thank you. I hope you'll bear with me with a little less light because the presentation is not visible from here. But we better this lighting is good, but we'll try to improve it a little more so that everybody can see. So, thank you, Professor Manoj Sinha, our friend, member of the Executive Council, Vice President, and who's had a long association. B.K. Malhotra ji, Law Secretary for years, and then so many other positions he has occupied, it's impossible to list them out. And he continues to help us. Saju, my good friend, Vinay, who's been our great support. And of course, all of you who are here from very far off, a very good evening to you. So I just changed my topic a little bit, and I've called it Abuse, Misuse, Ineffectiveness of Reservation of Treaties by States and the Remedies under International Law. So, we're sorry, we're trying to get the screens in front, which has been delayed, but we'll try to get it there. This is just an overview. What is reservation of a treaty, objectives, characteristics of reservation treaty, reasons why why states invoke them, then the conflict with respect to that, forms of reservation, objections against treaty, reservation of treaties, representation for the purpose of formulating reservation at international level, human rights treaties. And that's where I am going to be focusing a little, how reservation of treaties has affected human rights. So I come to that point. Although it is, my subject is brought under the Indian courts, etc., but I'm trying to go to fit into it, but my main is an international law focus, and I will try to connect it with some of the Indian things, because, and then of course wartime, ineffectiveness and misuse of reservation and human rights treaties by states, and how it works during wartime, and do we need the reservation with respect to human rights treaties entered, what could we do, alternatives, and conclusion. So that's where we are. And so now, when we, for all of those, and I'm making a basic presentation that the treaties that we are in, conventions are just an international document regulating the affairs of the state. You know, it's like a contract. So that is what a treaty is between any two nations. They're bilateral and multilateral treaties. The member states of the treaty shall implement the treaty at its land, and not necessary that the member state shall adopt and implement the treaty as such. I wish Dr. Narendra Singh was here. He would tell you, being heading our legal and treaties division, and how the ratification and adoption and various aspects of a treaty law is there. So member states need not implement the treaty. They have signed as such. They can modify or alter, but shall not tamper with the objectives of the treaty. That's the basic thing. You can modify, you can do, make some reservations, but the basic object can't be tempered. Now all of this, what is called the reservation of treaties, is envisaged by the Vienna Convention on the Law of Treaties. As you know, Vienna Convention is like the sort of the parent of all international law and diplomatic thought that we have. And here the thrust will be given to reservation on human rights treaties and the state practice. Now, reservation is a unilateral. Now, what do we mean by reservation of treaties? What is this thing? This is where is the core thing, and this has created a lot of problems in implementation of treaties in various ways, and I think it's a great stumbling block in international law. Reservation is a unilateral statement made by a state when signing, ratifying, or acceding to a treaty, whereby it purports to exclude or to modify the legal effect of certain provisions of the treaty in their application to the state. So what they say is that, yeah, I'm going to sign this treaty, I'm going to, sort of ratify or try to have my parliament pass it, etc. But I have some reservations about it. And that's what basically what reservation is. Now this is defined in section 2(1)(d) of the Vienna Convention on the Law of Treaties, which is again the Magna Carta, or Constitution, or whatever you might call it, the Vienna Convention, and that's what you must remember. A unilateral statement. Now what does 2(1)(d) say? A unilateral statement, however phrased or named, made by a statute or by a state, when signing, ratifying, accepting, approving, or acceding to a treaty, whereby it purports to exclude or to modify the legal effect of certain provisions of the treaty in their application to the state. So we make reservations. We will do it in this part, we will not do it, we'll do it in this territory, we'll not do it in that territory. When they sign the treaties, they are reserving to themselves some things which they will do and some things they will not do, some do's and don'ts, and that's what is the reservation. And that's how we'll see how these reservation to treaties has been bringing stumbling blocks in international law. Now, characteristics. As I said, it excludes or modifies the legal effect of certain provisions of the treaty as a whole with respect to certain specific aspects of application or to the state or to the international organization which formulates the reservation. So it can be a state, it can be an international organization, they will see. I will see a little more on that, how does these reservations work. It provides rights to states to abstain itself from complying certain provisions of the treaty. It also allows the states to mold in such a way that the provisions shall be made available with respect to the suitability of their land. That is their law of the land. Our India, suppose India makes some reservation, we sign a treaty and we say, we have this reservation, we will not apply it in this particular state, we will not apply it in these conditions, we will not do it. So that's what reservation of treaties, very simply put, means. It may be withdrawn at a later stage, you can give some kind of objections, and it may be, but it should not be completely incompatible with the objects and purposes of the treaty. Now, what are the objectives? The objectives are to bring harmony in the states which are abiding the treaties in accordance with the natural. They want to sort of incorporate it into their national laws. It should not be inconsistent. Then many states will have their own laws with respect, because the original thinking in the at the time when the Vienna Convention came into force was, we are all independent countries, we have all our own laws, but we will try to comply with these international treaties, but we will try to do it with respect to how it works for us and how we can make it happen, and so on and so forth. So therefore, it is tried to weld it and bring it together with national laws. To encourage implementation of treaties signed by the states at domestic level, to achieve the objectives of treaties which are crafted by the framers, we try to achieve it in our own way, to maintain state level of decorum and subject matters to the subject matter so as to achieve international level discipline on the affairs to treaties. So that's basically the way. Now, why do they take it away? Again, very simply, they may have, they don't want to yield to certain substantive points which they believe it is against their interests. They may also feel that it is binding, it's too strict and rigorous, they have too many procedural obligations, it may lead to compulsory settlement of disputes. Countries want to maintain their sovereignty. They are sovereign, we are independent sovereign nation. We want to comply with it, but we want to do it our own way. We want to do it without being, without having a stick on our head, without us being compelled or forced to do it. The state may wish to assure that treaty obligations are compatible with peculiarity in local law, and similarly, state may want to preclude treaties application to subordinate political entities and federal system, or to foreign territories for which the state would otherwise be internationally responsible. Now, as you know, bilateral treaties is between two countries. By and large, if there are any reservations in bilateral treaties, it can be solved. Usually in the international law ecosystem, they don't have a hassle. If you have some reservation and you sort it out among yourself, and they are usually for international waterways, trade and finance, military alliances, settlement of disputes with neighboring countries, and highly specialized international regional organizations. Sometimes you will have very close countries doing that. Multilateral are all arms control. Globally, the world big, everybody wants there should be arms control. Conduct of military hostilities, wars, educational and cultural exchanges. Many times you have, UNESCO does a lot of these things that give some kind of direction. Diplomatic and consular relations. These are very standardized multilateral treaties, that this is how diplomatics will work. This is how they will stay, this is how they will come and present their credentials, this is how they'll establish their embassies. So they are more, multilateral are more, in vogue, and they have greater adherence. Then international trade, intellectual property, law of the sea. Law of the sea, as you know, the seas are free for everybody. That Abed Pardo, the great Maltese diplomat, he coined the phrase, common heritage of mankind. The law of the sea is common heritage of mankind, and therefore we have greater freedom of seas because of the trade, etc. And protection of human rights. Now that's where we come to the point, and then we go to the... now what are the forms of reservation? It's by a unilateral statement. It says, no, we will exclude certain provisions of the treaty. We will, respect to certain specific aspects to a territory, particular territory, and so on and so forth, because many times there's a lot of strife. If I were just to give an example, the two territories adjoining Russia with the Ukraine, Donbass and another one of these which the Russians have occupied, Luhansk and Donbass, I think. They have been occupied by the Russians, who say that these are Russian-speaking territories and they don't belong to Ukraine, and so we want to come and invade their human rights are being violated, etc., etc. So that's one example of a reservation could be made. Reservation format, the jointly formulation of reservation by states where they agree, states or international organizations do not affect the unilateral character of their reservation, so that it is sort of respectful behavior between states. Then they are extended to territorial application, as I said earlier, in relation to that, just like that, the Luhansk and Donetsk example clearly fits this, the territory.
formulated by virtue of clauses expressly authorizing the exclusion or modification of certain provisions. So it says, you know, if we were to give examples of that, it would take long, but just to give you a basic understanding, what it tries to do is exclude or to modify the legal effect of certain provisions of the treaty with regard to the party that has made the statement and constitutes reservation. So all the time countries will do that, and they keep on making reservations. It's a whole, you know, not to use a wrong expression, of a jungle of laws which are dealing with these reservations and all that. It's very intricate, very complex, but to simply put is, countries just try to make it convenient for them to do it, a lot of them. But the civilized world tries to adhere to them in a better fashion and make others adhere. Now the civilized world, I don't mean uncivilized world, but let's say more organized world, more advanced world. When we talk about the civilized world, more legally compliant, more enlightened. So when we talk about the Western Europe, or you know, the permanent members of the UN and so on. Now, what are the objections? Again, sovereignty is the basic objection. They want to join the treaty, but they have a problem at home. Somebody is from some Latin American country or some country where maybe democratic forms don't operate, but they want to show to the world, you know, the leaders in the world would say, okay, yeah, we are ratifying this treaty, but they don't want to actually go back and do it fully. They want to make a sham show, and that's this thing. Ratifying at home level as it incurs special costs or something else. Okay. Now, representation for the purpose of formulating a reservation at the international level. So how is it done? It is usually done by their ambassadors or persons who have been given full power, or they authorize these people to make these reservations. It's all done through diplomatic channel, permanent representatives in that country who will come and place the reservations, and it's done through you know, state diplomatic practice. Then representation for purpose of formulating, it's the same thing. Heads of state are one, heads of government, minister of foreign affairs, representatives, accredited diplomatic personnel, that is to an international conference, or where the treaty is to be adopted, represented, accredited by states. The whole lot of people the government authorizes to make those things. Now, ineffectiveness. Now, I don't want to use, I've put it in three parts: abuse, misuse, and ineffectiveness. When you do reservation to a treaty, you make it, render it ineffective, because the treaty is meant to do certain things. If it says that you must have human rights, values for human rights, you must create systems, you must create a National Human Rights Commission, and you want to create certain reservations. Yesterday we had, this morning we had Dhaneshwar Mule sir, who said that it's often called a toothless tiger, the National Human Rights Commission. So it is not that effective. So some of those kind of things. So it occurs when reservation undermine the object and the purpose of the treaty, contradict the fundamental principles of the treaty, or violate preemptory norms of international law. Or you make reservations which renders it ineffective. It therefore defeats the objective of the treaty, like the Human Rights Universal Declaration, etc. Now, whatever else, if the state makes reservations that significantly undermine the core principles and objectives of a human rights treaty, it can be considered misuse. Now, we'll come to misuse in some countries, and we'll say, then, for instance, the reservation that completely negates the essence of the treaty's protection and is to be may be criticized for that. Also, reservations that violate jus cogens or preemptory norms of international law, basic principles of international law. There are numerous of these. If they violate them, then you will say that this is a misuse of the reservation. You have done it to misuse the law of the sea. You have done it to misuse the outer space. You have done to misuse other things, because you have made these reservations so that you can misuse the law, despite the fact that it exists, despite the fact you may have given, may have signed, may not ratified, etc. Suppose there is a reservation that permits torture. Now, it will be human rights. So suppose you make a reservation, yes, we will allow torture to happen. That's a violation, and that reservation violates it. If they say, no, in certain conditions we have to permit torture in our jails. So that will be so some of these, I mean, I'm just giving you an extreme example, but they give it in nice diplomatic language where you can't catch them doing wrong things. And for example, reservation that permits torture or discrimination on prohibited grounds could be considered this. States making overly broad or vague reservations that don't clearly specify the nature and the extent of the derogation also may be criticized for this. This can create uncertainty about the states committee to treatment, the treaties. Many countries you will find do not adhere to it. They try to escape through various legal principles. Then discriminatory practices, we've said reservation, avoiding compliance, making it conditional on some changing circumstances, or it withdraws. So we'll see that. Now, two examples, not to be terribly critical, but generally to just give an example. The United States, in the General Assembly unanimously adopted the International Covenant on Civil and Political Rights, but which entered into force less than 10 years after that, because the period usually are long for entering into force. People will sign, ratify, etc. But however, the US was missing from among the group of countries to have signed and ratified the country. So that's an example, clear example that you were there in the beginning, you were signed, and when it came to implementing, etc., you vanished. Congress considered now, this is another US, the US has not signed the law of the sea, the US has not done the Kyoto Protocol, some of those things, I mean, it has just avoided it, and therefore we can criticize them. It need not necessarily mean that they are bad or anything, but like they need to adhere it better, they need to show that they are democratic. Congress considered the ratification of treaties during 1960. During this era, state-sponsored discrimination was prevalent in the US. Senator Bricker was concerned that the ratification of these treaties would invalidate the domestic laws which facilitated discrimination against women. One of the senators is saying that, we will not be able to do this discriminatorily. He proposed a constitutional amendment that would severely limit the treaty power given in the US Constitution, making all international agreements non-executable. Now, the US further, while the amendment did not pass, it had further far-reaching effects. The US did not become a party to any human rights treaty until 1988, when it ratified the Convention on the Prevention of Punishment of Crime of Genocide. When they came to genocide, then only they came and did that. Moreover, as noted by Professor Taifa, the current US approach of attaching non-self-executing declarations to such covenants and conventions effectively accomplishes the original goal sought to by Senator Bricker and others to render international human rights treaties impotent under the US law. So therefore, that is one of the. Similarly, it finally ratified the ICCPR in 1992, and had so many reservations and understanding. So we take US as an example of this, but others do worse. So therefore, that is one thing. Then the US made reservations to the ICCPR provisions on prohibition of war propaganda, capital punishment, cruel, inhuman or degrading treatment, criminal penalties and juveniles. They made these reservations, the US themselves, the largest democracy in the world. That doesn't mean, I'm just giving you an example. I'm not against the US, I think it's a great country otherwise. I like to say that. It made understanding concerning the provisions on equal protection, compensation for illegal arrest, separate treatment of the accused for the country, because they are constantly in war somewhere or the other. If they keep on implementing this, they will not be able to deal with their, international, sort of position that they have given to themselves of being global policemen or whatever you may call it. And the extension of the provisions in the treaty to federal states, finally it made declarations with regard to treaty being non-self-executing, the rights that may be taken away during emergencies, the Human Rights Committee and the Savings Clause of Natural Resources. So therefore, it is, in say, emergency provision, they can, self-defense is another one, they go and invade country. So these are some of these things, and the other smaller countries will adopt them because they are set as an example. Now China, I have used the word misuse of reservation of human rights treaties. China clearly misuses human rights treaties, the reservations. The Uyghurs of China, if you know, are a great living example where they have just confined them, they have taken away their rights, they have taken away their rights of religious beliefs. It's a globally accepted fact that China misuses its reservation in human rights law. It's a clear, living, great example. It's not a great neighbor to us. We don't have to mince words about Chinese behavior, not only in human rights, but it is probably the worst, detractor of human rights, and in so many other things, law of the sea, etc. I don't think I need to be diplomatic or mince words about China's misuse of human rights. They are a violator of human rights. Now that's the reservation. So if I violate it, nobody can tell me, nobody can check it. But if but I will sign the Convention on Elimination of War to settle disputes between it and other states concerning interpretation or application of the treaty. The International Covenant on Economic and Social and Cultural Rights. China has declared that the right to form trade union or join a trade union of one's choosing must be applied consistently with the Chinese constitution. So it will regulate whether there will be only one trade union of one party or otherwise, but that no rights to trade union can be given, only one trade union can exist, it's our constitution, so therefore this is a reservation. That means it nullifies it. What's the point of signing something like that? It must be applied consistently with the Chinese trade union and labor law. Note that a number of European Union states have lodged formal objection that this effectively a reservation that is incompatible with the objects and purpose of the treaty. The Europeans have not minced words. We have more greater democracy in the European countries. And now, after treating specially administered region, the Hong Kong, what it has done there, and there is a serious violation of human rights in the specially administrated region. They restrict the right of trade, even in SAR of Hong Kong, to participate in trade union federations outside Hong Kong. China has also declared that the right to work does not preclude the employment restrictions. It applies to non-local workers in SAR of Hong Kong. So, people who work from outside, they can impose restrictions, which means that they can take away their human rights. They cannot appeal if they are put in prison, so on and so forth. They have put it in Hong Kong as well. Now, Indian law, I don't need to go into it. I just, Professor B.K. Malhotra sir has said sufficiently, but these are some of the Rudal Shage compensation. Nibabati Behra Orissa court held that Article 32 has not only the power to acknowledge the violation but also grant remedy, and D.K. Basu, Supreme Court issue pertaining to arrest and custody. These are some of the cases. And then effect of reservation during wartime. This is very important. They say everything is fair in love and war. Israel and Palestine both accuse each other. But again, Putin's Russia and Ukraine, states can only formulate reservations when signing, ratifying, accepting, approving or acceding to a treaty, not at any other stage. So you are saying that you reserve there, then you at wartime you do something else. States that have second thoughts cannot formulate a reservation after they are already party to a treaty. They would have to then denounce and re-ratify with a reservation. However, denunciation of human rights treaties is not always possible. You can't do it, but states evade and escape there through reservation. Now, just a few points before I conclude. What are the pros of reservation in the arguments for human rights? Safeguard of national sovereignty, encourage wider participation in the country, all wholly espousal, or allow adaptation to diverse legal and cultural systems. Some countries will say, no, our religion doesn't agree with this, and we may have some law which will cut out the hands of the people and so on and so forth. So they will say, no, this doesn't, or we can behead them, or we can whip them publicly, or any of these things. They will say that is our law, and therefore you can't make us adhere to some of the human rights standards that you're talking about. Even Singapore does that, for that matter. Risk, what is the cons of against the reservation? Risk of undermining fundamental treaty principles, potential for selective implementation of the provision, concerns about violation. The arguments against are these, possibility of discrimination. Then international bodies try to balance these two divergent views, for and against. I have told you both. Then they try to evaluate the legality of reservations. They make diplomatic efforts to have a constructive dialogue, crucial to the reservation, aim to ensure reservation contributes treaty effectively. They try to educate people, they try to bring them into the thing. They say that this is not how it is, we in the rest of the world. So the diplomatic forums and the UN organizations do that. Here, the role of the International Criminal Court is very great. This establishment is a great feature for the world. It is there to improve the world. Interestingly, the International Criminal Court issued a warrant against one of the presidents, you know whom I am talking about, and the foreign minister said, please look towards the sky. Please look towards the sky. You know what that means? that something will come and hit you. So the International Criminal Court was told that if you have issued a warrant against our president, please look towards the sky. This is what countries with veto power, big countries do. But nevertheless, the International Criminal Court is a very good moral authority to comply with international criminal law for genocide, for any of these things. Please read up on International Criminal Court. You must. We had the Secretary General. Our Secretary General invited him, or the President, Krish came here, and then it engages the state parties to ensure that domestic legal frameworks align with the obligations set forth in the Rome Statute, the treaty establishing the ICC. Importantly, the ICC jurisdiction is not subject to reservations, operating on the principle of complementarity. This means it can intervene when national legal systems are unwilling or unable to prosecute specific crimes falling under. We've yet to see that, but then it can do that. Now, the UN General Assembly is a great body for debate and deliberation to ensure the effectiveness of the human rights. The Human Rights Council, UN Human Rights Council itself, which deals with it in here and down, they are an effective body. Now, I have made one point about the Security Council, how we need to have the Security Council, then only it will be an effective implementation. That is, the expansion of the Security Council to include all emerging and important stakeholders. We are an emerging and important stakeholder, that is India, is a need of the hour for democratic and healthy functioning of a global system. That's one of the things. What are the alternatives? You insert in the treaty a clause permitting to limit the scope of the application of reservation or specific provisions which make it very, very difficult to exclude or modify the legal effect of the treaty. And I'm on my conclusion, sir. Please don't be nervous about going there. So what are the conclusions? What do we do that? We must restrict the scope of reservation of treaties where the key elements are preserved, and you cannot have too much leeway in making reservations. Often reservations are misused, is what studies have shown, worse in the times of war. And since international law gives paramount importance to sovereignty, it is seen that sovereignty must be upheld. And the ICC, as we can see, has become is likely to become ineffective, or is not, or it will not be effective. And I gave you an example of when the warrant was issued by the ICC, the foreign minister of that country said, "Please look towards the sky." So you can imagine what it means. So the veto power is another thing that comes in the way. It has to, if we expand the UN General the Security Council, less veto powers can be exercised, and we need to see that in future. It can be seen that India, as Professor Malhotra and Professor Manoj Sinha, they have told you that India is a paragon, shining example of upholding human rights. Our Human Rights Commissioner, for those who have been present in the morning, Dayaneshwar Muleji, who was also a former diplomat, and now on the Human Rights Commission, said that we have made 250 crores of compensation. We go and ensure that we are not a toothless tiger. So India is a great shining example of upholder of human rights. And I have something for you, which I just incorporated this afternoon, the takeaway thought. Teach your children early what you learned late. And that is for you. Thank you very much.
So thank you very much, sir, for very comprehensive and detailed presentation on reservation. Just I'll add a few points on that. So reservation, it depends upon each treaty has reservation clause. If a treaty is silent on the reservation clause, the state cannot make a reservation on that treaty. Even if the state can decide not to ratify that treaty. So reservation clause, it's there. It's the idea behind the reservation is that it's implementation issue. Take an example with and this has become very common, as you rightly pointed out, sir, in the human rights treaties. Human rights treaties, generally when a state makes a reservation, other state has to object the reservation of the treaty, which was silent in the international human rights law. And that became a big issue. So before the Human Rights Committee, in the Human Rights Committee, particularly General Comment 24, which talks about the reservation multi. And then Human Rights Committee has clearly stated, a state has a right to make a reservation on human rights treaty. However, they should not make a preservation or a provision, and the decision will be taken by the Human Rights Committee whether it stands in the test of the Human Rights Committee on the substantive provision. As you said, torture can be if a state makes. So it defeats the entire purpose of the torture convention. If right to life you make in the Article 6 reservation in the international covenant, so it defeats the entire purpose of the international. So the idea is to make a reservation. And like you see the WTO, though the reservation is not there, but they have given a state 10 years period, TRIPS agreement. You can't implement immediately because our law is not in consonance with the WTO in 1995. So many developing nations were given some kind of grace period for 10 years gradually. So implementation is more linked with the reservation, but as you said correctly, it's a misused. And that is the reason in 1994 Human Rights Committee came into picture and said we will decide whether reservation is valid or not valid in there. Then also in the ICC, sir, reservation, I'm not quite sure, but it talks about the opt-out clause. There is an opt-out clause where one state can go opt out for the 7 years or certain periods from the implementation of the war crimes, out of the food crimes is there. Let me just focus one important point, which is very important in the Indian case, and sir has rightly pointed, Nilavati Behera versus state of Odisha. This case is significant when we discuss about the reservation, because the former Chief Justice of India, Justice J.S. Verma, was the judge in that particular case. He cited Article 9, Paragraph 5 of the International Covenant on Civil and Political Rights. What is Article 9, Paragraph 5 of the International Covenant on Civil and Political Rights? It talks about a state has to pay compensation in case of illegal detention, if somebody is detained. What Government of India has said, and that particular on 10th April 1979, we acceded to the International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights. We made a reservation. Declaration basically reservation regarding the Article 9, Paragraph 5, saying we don't have any laws, neither constitution or nor a statutory provision, so we are not going to implement because we believe in the concept of sovereign immunity. Officers are working on the behalf. Thus, Article 9, Paragraph 5. But court did not look into that. The court used that Article 9, Paragraph 5 and said, we have to pay compensation because we are party of the International Covenant on Civil and Political Rights, and specifically mentioned. So young teachers, students, what sir has mentioned, that you look into the Nilavati Behera case, that is important. Even state government of India has made reservation regarding the Article 9, Paragraph 5, but court has ignored that one, and it might have not been brought before the court notice, but court has used that there is an obligation on the government of India to implement and granted compensation to the victim in that particular case. So it's a very interesting, and sir has in a detailed, very country perspective he also gave about the China, Russia and others, UN General Assembly, all these aspects have got. I'm sure that as you said, for the young children it's a great lesson and they will follow the reservation aspect and international law perspective. And what sir also mentioned about the Vienna Convention of Law of the Treaties, that is considered mother of all treaties. So when you have a doubt, what reservation means, what signature means, what ratification means, you go back and look into the Vienna Convention of Law of the Treaty, your doubt will be removed. With this I end here and request Swaju sir to come and share his thought about this topic, which sir has Supreme Court and human rights.
Thank you very much, Chair. Honorable Professor Manoj Sinha, the head of ILI, Manoj Misra sir, the Honorable Manoj Misra sir, the former secretary, and my learned senior friend as well as senior advocate, Dr. Rao, who is also the vice president of ISA, and also my friend who is sitting very near to Ganesh. And finally, good evening to all of you. I can see myself sitting among you and hearing all these learned lectures from the learned colleagues. And I used to sit here 20, 30 years back as a student And I used to hear such kind of lectures. And I understand that you are also very much tired after having heard a lot of lectures, and you must be suffocating right now because of the lectures that you must have heard. Nevertheless, it is also very important to learn all these international aspects of the human rights, as well as the development that we in India have made in the realm of human rights, especially the development given by our Honorable Supreme Court of India. The famous judgment talks about a very famous statement. The pulse of an ordinary human being is being beat at the heart of a Supreme Court, which indirectly and directly throws the blood and oxygen into the lives of human beings through various judgments. This is one of the famous statements made by a judge in the famous case law, which is very much known to all of you. That is the Keshavananda Bharati versus Union of India, which has propounded and propagated the theory of basic structure. At the heart of our rights, the Supreme Court is the guardian, conscious seeker, conscious protector, ensuring everyone's interest and everyone's music is heard in the song of justice. That is another famous statement made by another judge in the similar judgment, which is also very much known to you, that is Puttaswamy judgment. These are the two important judgments that is very much relevant for all of us to discuss. As we gather today to celebrate Human Rights Day, it is imperative to reflect upon the role of judiciary, especially and particularly the Supreme Court, which is the guardian. And that right of guardianship is protected through Article 32, and when it comes to High Court, it is protected through Article 226. The Supreme Court of India, being the highest court of law, has always protected and played a greater role in ensuring the human rights development in the ordinary lives of Indian citizens. The preamble itself talks about the human rights, and the Constitution, the part 3 and 4 clearly talks about the fundamental rights as well as the human rights. Article 14, Article 19 and Article 21, which is the famous triangle, golden triangle rights of Indian citizens. The human rights in India are not protected only because of the incorporation of its rights in Universal Declaration of Human Rights, but by the very spirit of Vasudeva Kudumpakam. As you know very well, Vasudeva Kudumpakam means the fraternity. We all are one in one family. That itself shows that the fraternity, assuring the individual dignity to all its citizens, whether we are Indians, whether we are foreigners. But Article 14 and Article 21 gives these rights to all the people living in India, irrespective of the fact that whether they are Indians or foreigners. This is the beauty of our Constitution. As you know very well, all these fundamental rights are developed as a consequence of various revolutions that we have fought during the struggles that we have made against the British regime. As you know very well, the world has also witnessed a lot of revolutions. French Revolution, American Revolution, and also various renaissances that we have witnessed during the 19th and 17th and 18th century. All these revolutions have led to the fact that there is a declaration of human rights at United Nations in the year 1948 on December 10th, that is tomorrow, and we are celebrating the Human Rights Day today and tomorrow. The Indian Supreme Court, apart from the basic structure theory, has also developed various fundamental rights. The first and foremost fundamental right, according to me, is the expansion of locus standi. Any human being, as Sir has rightly said, any human being can approach Supreme Court and High Court even by sending a letter under Article 32 and Article 226, and it has later developed into the form of public interest litigation and the famous case of S.P. Gupta and also Lily Thomas. These are the two important case laws that we have developed. The Indian Supreme Court has developed in this jurisdiction. Of course, the public interest litigation, though it is actually a borrowing concept from American jurisprudence, but it was developed in a different wavelength, and we have now established the fundamental, public interest litigation as a matter of fundamental right. Though Supreme Court recently has sometimes dismissed public interest litigation with a fine, but with fine or penalty, because there are a lot of lawyers who have started filing public interest litigation with the small demands and all. But in most of the cases, Supreme Court has accepted the public interest litigation as a matter of instrument to file such kind of cases. The rule of locus standi, right to move to the court, whereby only aggrieved person can approach the court for redress of his grievances, has been relaxed in the famous case of S.P. Gupta. Now the court, through public interest litigation, permits all the public spirited persons to file writ petition for the enforcement of any other person, not only of our right, but of any other person or a class, if they are unable to invoke the jurisdiction of the court due to poverty or any social and economic disability. Similar observations have been made by Supreme Court in various judgments, and public interest litigation has now become a tool for the protection of human rights of people in India. The oppressed section of the society are more prone to the violation of human rights. Most vulnerable sections of the society are children, women, and other poor people. Children are not only prone to sexual abuse, but they are also sometimes kept as bonded laborers, as was the case in the People's Union for Civil Liberties versus Union of India, where the Supreme Court leased child bonded laborers and ordered for grant of compensation to them. Supreme Court has also played a remarkable role in protection of human rights, such as in the case of Associate Bank Officers Association versus State Bank of India, wherein the Supreme Court protected the rights of women workers and held that the women workers are in no way inferior to their male counterparts, and hence there should not be any discrimination on the ground of sex against women. In the Vishaka and others versus State of Rajasthan, which is generally called as Vishaka guideline, the Supreme Court have again set out guidelines which is very much relevant in today's life. Another woman based judgment is the Shabanu case, in which Supreme Court has made an important decision with respect to the Muslim community, promoting the interest of human rights. Promoting the interest of human rights, again Supreme Court has made one more judgment in Sabarimala case, which is also very much known to you, and it is filed by Indian Young Lawyers Association by versus State of Kerala, which is also a very famous case law with respect to the promotion of human rights. The women were given the right to enter the Sabarimala temple without considering their age. That is what the communities, many communities have said. But the Supreme Court has finally accepted that the women have the right to enter into the Shabarimala temple. Furthermore, the court's intervention in the Shayara Banu versus Union of India, the famously called triple case, which is also very much known, and that is also made by 3-bench judge for the purpose of promoting the human rights. In the matters of adultery, the famous case called Joseph Shine versus Union of India, Supreme Court again reasserted that a husband is no longer the master of his wife. Pronouncing adultery as not a crime, the court emphasized that it violates the dignity of woman, constituting an infringement of Article 21. However, the court clarified that adultery remains ground for divorce and can be considered a criminal act if it leads to abetment of suicide, warranting prosecution under Section 306 of the IPC. The Supreme Court protected the rights of workmen in various cases, namely Balco Employees Union versus Union of India, Consumer Education and Research Center versus Union of India, People's Union for Democratics versus Union of India. All these are public interest litigation, PAL matters. The Supreme Court has stated that releasing person from bonded labor was connected to the rehabilitation process in order to give full remedy, to the bonded laborers. That means bonded laborers are released from their prisons, the so-called classical prisoners, but they should also be given full remedy to protect their human rights. In Workmen versus Rosas Industries, the Supreme Court observed that the right to equality became instrumental in protecting the rights of workers against unreasonable closures and discrimination in payment of pensions. Another famous case law, that is D.S. Nakaras versus Union of India, in which Supreme Court has clearly stated that pension and gratuity are not bounties, but it is actually the constitutional right of any workman in India. That is also a very binding and very famous case law in the service jurisdiction. Supreme Court has very clearly said that the gratuity and pension are not anymore gratuity. It is not dependent on the mercy of the employer, but it is a matter of right for the workmen to demand from their employer. And as such, there are many petitions which have been filed before the Supreme Court as well as the High Court, and many people who right now are retired, they get their pension at their evenings of life. Our judicial system again, and especially the Supreme Court and the High Court, protect the rights of its citizens, and especially if they are in jail. The name of Justice V.R. Krishna cannot be forgotten in this matter, because he is the champion of prisoners' rights on the basis of Constitution. The Supreme Court, by interpreting Article 21 of the Constitution, protected and preserved the rights of prisoners. In the case of Prem Shankar versus Delhi, the Supreme Court held that practice of using handcuffs is prima facie inhuman and therefore unreasonable. It fetters on prisoners and violates the guarantee of human dignity. Another landmark judgment, as we have already heard, D.K. Basu versus State of Bengal, Supreme Court protected the rights of prisoners and laid down various guidelines for arrest and detention to prevent custodial violence, and observed that the right to life includes the right to live with the human dignity. Similarly, the Supreme Court in Sheila Bas versus State of Maharashtra, court also talked about the mistreatment of women in police station and laid down various guidelines for the protection of human rights among women, especially the woman who is incarcerating in prison. In Citizens of Democracy versus State of Assam, the Supreme Court held again that handcuffing and tying with the ropes is inhuman and in utter violation of human rights guaranteed under international as well as our law. As we again talk about the Supreme Court's primary role in upholding the human rights, we are entering into a very important jurisdiction, that is the basic structure doctrine, which is propagated and propounded in the case of Keshavananda Bharati versus Union of India. This case was heard by an unprecedented constitutional bench of 13 judges. The judgment defined the authority of the Constitution over the Parliament and over any other parliamentary constitutional organs. Neither Parliament nor the judiciary is supreme, but the Constitution is supreme. The Supreme Court has held this theory through its basic structure, and the amendments, whether it is Parliament, whether it is by Parliament or by state legislature, if it is abrogation of a fundamental right, it can be declared illegal, ultra-vires and unconstitutional. And the Supreme Court has in various case laws struck out such kind of laws. Amongst the notable and historic judgments the Supreme Court has made, that is number 1, Shreya Singhal, which has struck down section 66 of the Information Technology Act. And another one is actually the Puttasamy matter, the Puttasamy case, holding that the right to privacy is a protected fundamental right in the Constitution. Then we have actually one more case, Nigesh Tarachand Shah, which has struck down section 45 of the Prevention of Money Laundering Act, imposing twin conditions for bail. These are the famous case laws which has been struck down by the Supreme Court on the basis of the judicial review as well as basic structure. In pursuit of justice for rights of transgenders, the Supreme Court has again recognized the transgender community as the third gender, affirming their rights in a historic judgment in 2014 in the case of National Legal Services Authority versus Union of India. Right to love any person of his choice or her choice is guaranteed under the preamble of the Constitution, which accommodates plural ways of life and embraces diversity. In the case of Navtej Johar Singh versus Union of India in the year 2018, Supreme Court decriminalized section 377 of the Indian Penal Code, aligning its decision with the constitutional principle of equality and liberty. This significant stride marked the end of a 72-year struggle of a woman, granting equal rights to the LGBTQ plus community. In the case of K.S. Puttasamy and others versus Union of India, the constitutional bench of 9 apex court judges unanimously ruled that the right to privacy is an inseparable part of all human beings and their personality as a whole. The same was recognized under Article 21 of the Indian Constitution, which defines the right to life and personal liberty. In the case of Aruna Ramachandra Shanbag versus Union of India, Supreme Court ruled that individuals have a right to die with dignity, allowing passive euthanasia with guidelines. The need to reform India's laws on this area was triggered by the tragic case of Aruna Shanbag, who lay in the vegetative state. However, amidst all these triumphs of justice, we have also some dark side, which is also very famous case law, as you all know, ADM Jabalpur, in which Article 14, 19 and 21 were suspended during the period of emergency. And when the matter has come up for the Supreme Court has justified such kind of suspension of fundamental rights during the emergency period. But luckily again, it was also overruled by the right to privacy case law, which is the Puttasamy, in which the Supreme Court has indirectly overruled the said famous ADM Jabalpur case. Recently, I have noticed a very slight change in the stand of Supreme Court. Generally, Supreme Court is a champion of fundamental rights, champion of human rights, and they have been pioneering various principles with respect to human rights through its judgments. But with respect to the abortion, as you all know very well, in the year 2022, we have had a very good judgment which has taken all of us forward, which has taken the humanity forward, and that judgment allowed any pregnant woman to abort on her own choice. And the humanity as such, the world as such, and especially the modern thinking world as such, has very much clapped this judgment, has very much encouraged this attitude of the Supreme Court in promoting such kind of human rights. But there is a general saying about us Indians that we take one step ahead, but we, after some time, we again take two steps backwards. In 2023, October, November, Supreme Court, the same Supreme Court has said that though there is a right for woman to abort his or her own child, but if the child is grown up in fetus, it cannot be terminated. Though I don't see morally any mistake on that judgment, but as a matter of policy, legal policy, in terms of human rights development, Supreme Court could have actually taken a different stand. And the Honorable Justice Nagaratna has taken the woman-centric approach in that issue, which is, according to me, the right stand. Whereas when the doctors, one of the doctors who have actually supported the termination of the pregnancy, has later reported to the Supreme Court saying that the medical condition of that particular woman is very much deteriorating and accordingly it shall not be terminated. And the Supreme Court, consisting of two benches, Justice Nagaratna as well as Justice Pauly, they have taken a different view, divergent views in this matter, and finally the matter was taken to the Chief Justice's bench with the three benches, and the Supreme Court has finally decided in favor of the child. This is the most recent development in respect of human rights. Otherwise, our Supreme Court has been the pioneer, has been the champion, and the conscious keeper, and the guardian of the human rights, as well as the fundamental rights. As many of our colleagues, as many of our panelists have clearly said, India stands on higher pedestal when it comes to the protection of human rights. India, I have gone to Europe, I have studied over there, but because of the constitutional protection that India offers and gives, I have come back and I was very proud to come back and I start again practicing in India. This is moreover important for all of you to know that, and this is the time many Indian students go abroad and they don't come back. Everyone, those who go abroad should understand, should learn and should practice some period of time abroad. But finally, this country is a heaven of human rights and fundamental rights. The foundation of our Indian democracy is very, very strong on the basis of the constitutional rights. The values of our constitution talks about love, fraternity, justice, equality, and right to get equal protection from the government. In India, as the democracy stands now and grown up in this century, we are going towards a very strong country in terms of human rights protection. This is what I can see from my experience, considering the world development, as the panelists have rightly talked about. and especially the Rao sir and also Manoj sir has said that Indian laws protect constitutional rights, legal rights, civil rights, political rights, economic rights. What else do we want? What else do we want? You don't get such kind of protection anywhere in the world except few countries in Europe. All these things have happened because of the revolution that we have fought from 1857. And we should be thankful to our founding fathers who have given a very strong constitution to all of us, whereby our rights are protected. And it was their far-sightedness and wisdom that they have given the right of judicial review to the
Thank you, sir.
Supreme Court.
Let me know with the interest of time.
Thank you very much.
Sir, you very nicely you have outlined and highlighted all important decisions of the Supreme Court where court has implemented various provisions of the Constitution, particularly Article 14, 21, 19, and even 25, 26 you have mentioned that this is privacy case and other cases you have mentioned. And we also just I want to add because I don't want to go on, but during the COVID phase, High Court and Supreme Court equally played very important role, and particularly two cases were taken by the suo motu then Chief Justice. One was taken in 2021 by the Justice U. Lalit and another by Justice Chandrachud. First was related with the admission and recent burial of the recent burial that was there. And second case related with the oxygen and vaccine. And that is the policy which had been set. So, of course, as you said, and you have encouraged, motivated the young students to stay in India, go back. আপনার যদি বাইরে যেতে চান যান পড়ালেখা করে আর তারপরে ফিরে এসুন এখানে রাজধানী ও ওয়ার্ক করিয়ে দেয়া ওকে লাইক তো স্যার বলতে চান আপনাকে সো ইউ ডোন্ট স্টে দেয়ার থ্যাংক ইউ ভেরি মাচ সো আই জাস্ট হার্ড যে অনেক লোক এসেছে কলকাতা থেকে কনস্ট্যান্ট কলেজ থেকে সো তোমরা পড়ো যে স্যার বলেছেন ও মাথা দিয়ে ধরো আর ওভাবে কাজ করো ঠিক আছে ধন্যবাদ আর আমি নেক্সট স্পিকার আমি রিকোয়েস্ট করছি আমার বিনয় সিং নিজের লোক নিজে বলবে না যা
Thank you, sir. The earlier presentation made by Dr. G.D. Rao, sir, and also some comments made by the Manoj Kumar Sinha has made my task easy, and also set a, what you can say, base for me from where we can take forward the debate and discussion pertaining to the reservation to the Human Rights Treaty. The topic which I am going to reflect is the competence of the human rights bodies over the reservation to human rights. And this paper which will cover this aspect in the light of the work done by Law Commission. And so for what we see from the earlier presentation, we have discussed at length about what is the reservation of the treaty, and what so far position we can see from the Vienna Convention Law Treaty, that it remains to only let us to understand that what could be the, in what circumstances a treaty could be considered invalid or it could be considered incompatible with the object and purpose of the treaty. Now my task which I took for this presentation is to discuss what are the impermissible reservations and what is their effect. It means what is the consequences of the impermissible reservation. As already Dr. Rosser has at length discussed about reservation is a unilateral statement made by a state to modify or extinguish the effect of the legal provisions in implementing it. just this, and then further we also make to understand that Article 19 of the Vienna Convention, from Article 19 till 24, covers provisions pertaining to reservation of the treaty under the Vienna Convention of the Law. This is known as the VCLT regime, Vienna Convention of Law Treaty regime. And by reading this Vienna Convention Article 19 to 24, there is a general understanding, and even by reading along with the Genocide Convention, there is an understanding when a reservation is found to be considered is an invalid reservation. That is basically with a reservation which is incompatible with the object and purpose of the treaty could be potential to be considered as an illegal invalid reservation. Genocide conventions are what you can say reservation of the Genocide Convention. There was a ICJ judgment in 1951 which also somehow you could see that explained that how the Vienna Convention of Law Treaties could be applied on certain situations, and this has limited to suggest that if any provision reservation which is incompatible with the purpose of the treaty object of the treaty could be found to be invalid. But this judgment does not go beyond this only limited understanding. It does not reflect about the consequences of the impermissible of the reservation. So the classical approach could be for all of us to understand if there is any reservation is made and there is objection to it, either the objection has to be withdrawn, or the other position could be that reserving state could not become the party to the treaty. This is a general classical approach used to be there. Now, let's go to little bit more with related to human rights treaty. If you see the human rights regime under which you will find several treaty provisions pertaining to reservation, there could be possible to make them in a separate groups. Like there are two groups which can be identified by seeing the reservation provision in several treaties of the human rights. One group which you could see is that where that group would be toeing to the Vienna Convention of the Law Treaty. What does it mean? That it could only talks about if reservation is incompatible with the object and purpose. Could be similar version could be found in the various treaties of the human, like CEDAW, CRC, CRPD. These treaties talks about similar what being said into the Vienna Convention of Law. There are another group of treaty which you find which has been spelled in like that way. There are certain core provisions cannot be made reservation, like 1951 Refugee Convention, European Convention on Human Rights, and some other treaties. Besides that, there is a unique mechanism you could see into the Convention on Elimination of Racial Discrimination, where you will find that there is a provision which says that if there is 2/3 country object to the reservation, it could be possible the state has to withdraw. This is a unique formulation you will find in the Convention of Elimination of Racial Discrimination. Now, where the debate started and why this has went beyond to shape up the discussion and forwarded this debate and discussion to the International Law Commission to deliberate upon it. The general understanding over the years has been seen that human rights treaty is being considered a special kind of treaty. It is a norm-creating treaty. It is something it could have been argued that it is different from the treaty, multilateral treaty, which being dealt with between the state with related to commercial and other aspects, where the state practice would be one of the important aspects need to be observed. Considering this aspect into it and having this understanding, there was a what you can say argument developed among the scholars that human rights treaty is something special which need to be interpreted beyond the Vienna Convention of the Law Treaty, and this led somehow influences the process of the examining the validity of the treaty among the human rights treaty body. And you know very well, this is the Treaty of Human Rights Treaty, which has the human treaty body multi-mechanism, and by that virtue of it, they could have the, what you can say, the authority to interpret the provision of the treaty. So like in treaty body, International Covenant on Civil and Political Rights, there is Human Rights Committee, which made an observation that is known as, which Professor Manoj Kumar Sinha has mentioned about, General Comment 24, which has basically given competence, and by virtue of this article, General Comment 24 of the Human Rights Committee, it claimed that they have the competence to determine the incompatibility of the reservation with object and purpose. It means that they claim that they do have, they are the competent bodies to determine the legality of the reservation made by the state. By virtue of this claim, it has been, there are debates, certain debate stated, and this statement has been made in the light that once what I said, that there were general views were emerging that human rights, a non-creative treaty or something what is special character of treaty, and they do have a full authority to look into it and guide the states to how to go ahead with the reservation. Besides that, General Comment 24 also made another interesting point of it, that is the separability of the reservation from what we say, from several reservation which is made by the state. It means that severability means that the reserving state, which provision of the reservation is found to be incompatible with object and purpose, will be separated, and the state will continue, treaty will continue to be operative against the state, with the state. What does it mean? That once it is been separated, state remain to be party to the treaty. General Comment 24, which suggested like this line. So the first point, it said that it is a what you can say, it is a special treaty, something like that one. That is was one point. Second point, that they claim the competence. Third, that they have articulated that the severability of the reservation which is made by the state, which is found to be incompatible with the object and purpose of the treaty. Now on this 3 point, when the General Comment 24 came, United States and France objected, and since they have their certain experiences with the reservation, which was been found to be in ICJ discourse, and those discourse, if you someone look, could find that the committee also somehow it also echoed or followed the observation made by the certain judges in few cases of the ICJ. So there are 3 cases which give us a guidance to understand that committee was not something which should have claimed this type of competence. It is being from the thought was from earlier, and this thought was further been propounded by General Comment 24. I will take just 5 minutes, sir, not more than that. So by virtue of this, what you can say, the 3 cases, just briefly to tell you, there are 3 cases. That is, one is the Norwegian loan case, another is what you can say, this is the Nicaragua case and the Hinterhandel case. These 3 cases. In the first 2 cases, the first one cases where you will find letter passed, he has given a separate opinion. And in the second case, where you find the letter passed has been given a dissent opinion. And in the third case, which I am talking about, the Nicaragua case, it is Schwebel. He has given a dissent opinion also into it. So the rationale which will be propounded by 3.1, severability of the reservation, which I said that it was been within the ICJ, it was been there, the idea. was being found to be in three judgments, but these are the majority opinion judgments. Now, as I said that one, and in between the general, even before the general comment, then Alan Paley has made a remark after the genocide judgment on ICC judgment on genocide convention, the dialogue of the deep. He categorized the judgment after judgment, dialogue of the deep. To understand that, he might have challenged the understanding so far emerging. Alan Paley has been asked to be a rapporteur for the debate in the ILC, which is being begun with relation to treaty in 1993 and gave their final report in 2011. 17 reports has come into the process of it. And in 17 what you can say came, and all of us we know that ILC has a mandate to look about the progressive development of international law and codify the law. So in all these reports, after Alan Paley gone through all of the reservations, he found difficult to articulate a draft article, which could be said that could be taken further as a treaty or convention over there. He come with the proposal of the guide to the reservation to the practice. So it means that still you could see that ILC could not find that today whatever is going to be an aspect to be decided would not be going to be a final verdict. But it is known as a guide to reservation to practice, where if you look, you will find somehow the conflict between the understanding about the General Comment 24 and ILC report. ILC report also, the first one point on which human rights is a special character, universal character of the instrument, non-creating instrument, this understanding, it somehow is being not found very much support within the ILC. Since that the idea of the fragmentation is being seen to be also somehow to be understood in that context. So, but the understanding about the order public, somehow that order public character of the human rights is being taken as a matter to be further debated into the ILC. And this understanding has led that to see that ILC would go further on this aspect. Considering this point of order public, which could be somehow to relate with the special character, but not as was being given understanding earlier, it is being somehow to be seen. Somehow it could be special character, but not like earlier what we just seen. So what the outcome was that, if you look at one, outcome is being that what is said and it given right back to the state to claim the competence. So the outcome which has come, which says that the committee do have the competence to determine the legality of validity of the reservation, but also they have said that if any provision of the reservation is found to be what you can say incompatible with the object and purpose of the treaty, then a 12-month period will be given to the state to see whether they would like to continue with the treaty or whether they would like to withdraw the treaty. So this 12-month period could be seen to be given back the competency to the state to determine about whether they would like to be party to the treaty or not. So earlier what you can see that the General Comment 24, which took their competence and made immediately apply the treaty during the dispute, would have been once again brought back within the competence of the state. So this is some few points which I highlighted. Most probably some point I missed into it, but thank you for listening.
Thank you, Dr. Vinay. Just you made an attempt, very good presentation, and removed the ambiguities, intricacies in understanding on the reservation, and you have also given the three important judgment of the ICJ, competence of the Human Rights Committee, which you ended with saying the Human Rights Committee has a competence to interpret whether reservation made by the state is valid or not valid, and 12 months period. So lot of and then also Alan Paley. But there is like always if a strict approach is adopted by the international community when it comes to the reservation, then I think the treaty will be not signed by many states. So some flexibility is required, and that is very important. And that is the idea behind incorporating. And however, some states were making in the past very substantive provisions of the treaty, which defeats the purpose, object and purpose of a specific treaty. With this, we come to the end, and I think the students are very restless, and but still they want to continue. I think for another half an hour. They have some. If you have some questions and answers, but I think like we finish it here. Sir wants to make a comment. Before sir wants to make a comment, I want to end with a happy note, and because they are from the Calcutta and West Bengal, you're from Calcutta, no, sir? Yes, sir. Just like, and that credit goes to our Secretary General. So, long time back, Jyoti Babu, when he was Chief Minister of the state, so Gorbachev policy ki I want to come your country and see how you manage crowd, so many people there. So Jyoti Babu বলেছে ঠিক আছে কিছু অসুবিধা নেই আর হয়ে যাবে আপনি আসুন. Then he approached Subhas da ছিলেন উনি আগে sports minister. Subhas Babu Gorbachev আসছে মানে Subhas Babu Gorbachev will be visiting Calcutta and he wants a crowd, how you manage, so you have to do everything. বলে না কিছু চিন্তা করার দরকার নেই আমি করে দেব সবাই জিত হয়ে যাবে আপনি ডাকুন ওকে. You call him and then a day was fixed. And a huge crowd was gathered in a big city, and then Gorbachev was very impressed. How you manage in a very short spell of time. Then he said, no, I have not. My colleague has done. Subhas Babu has done. Subhas Babu tell him how you manage. Well, no, I have not done anything. So for Bangalore, I'll just hear. I just told everyone, come, march baat. So বলেছি সবাইকে বলে দিয়েছে আগে চলো ওখানে মাছ ভাত হবে. That Gorbachev thought, oh my God, everybody knows about the Marx bath. So he said, everybody knows about the Marx bath. How many people are extremely poor, but they are very much aware about the Marx bath. तो ज्योति बाबू बोले ठीक है तो माछ बोला था माछ भात पीस राइस माछ भात ऐसा बोलते थे मार्क्स भात बोले कि you have gathered so much big crowd, how you there is no arrangement কি হবে বলে কিছু চিন্তা করা দরকার নেই একটা বম ফুটিয়ে দেবো সবাই পালিয়ে যাবে কিছু করার this is the way. So now I over to you, sir.
Nice to hear Professor Manoj Sinha speak Bengali so fluently. Lovely language. It's very sweet. It's like the French language of India, and I'm glad he's able to do that and communicate with you better. But anyway, quick comment about the Vienna Convention on the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, and Professor Manoj also described it as the mother of all treaties. On the Law of Treaties, which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you know, Professor Manoj also described it as the mother of all treaties. The law of treaties which you use for and you know, Professor Manoj